Let's get back on the record in the Williams matter. A few moments ago, the jury came back with a verdict of guilty on all counts, and we are going to move into sentencing. Mr. Abate, if you would give me first your sense of what the sentencing options are based on merger, vacatur, et cetera. And then I'm happy to hear your argument. And if there are any members of Mr. Hardesty's family or friends of Mr. Hardesty's who want to be heard, I will certainly hear from them as well.
Yes, Judge. Obviously, count one, the defendant would be sentenced on. Counts 2 and 3, felony murder, would vacate by operation of law. Count 4, aggravated assault, would merge with count 1. And then I believe Your Honor would sentence on counts 5 and count 6.
The criminal damage to property doesn't merge into the felony murder because it's been vacated because there is the murder conviction and it stands alone. But the aggravated assault merges because it is an element, if you will, of the murder.
That's correct, Judge.
Okay.
And if it's okay with the court, there are 2 impact statements from Mr. Hardesty's mom and dad, Ms. Sherry Malone and Mr. Rodney Brown. And then upon the completion of their statements, the state will make a recommendation to the court as to what the state believes is the appropriate sentence. Okay.
And those are things you're reading, or those are people who are here?
They're here and present.
Great. So the way we're going to do that so the court reporter can hear you is I'm going to have you come up and you can sit in the chair that Mr. Abate is setting for you so that we can get your statement. So in whatever order you'd like to be up here, please.
Probably so. Just in my mind, it don't matter.
That would be Michelle. Huh. Okay. Good afternoon, sir. If you could start by sharing your name for the record.
Rodney Brown.
Can you pop the camera up? All right, Rodney Brown?
Yes, sir.
All right, Mr. Brown. What would you like to share with me?
He took away something from me that I can't replace. That was my only son. And it's gonna be hard on this family without him. These last years been rough. And it's just nonsense. It don't make sense. And then just try to swear his name the wrong way, talking about he robbed him. He ain't robbed that man. He ain't took that from nobody. He didn't have to take. And it's just lies, and he ain't gonna go away like that. He had a good son. And just can't be done, man.
How old was Mr. Hardesty when he was killed?
35.
And that's your only child or your only son?
My only son.
Only son. Did he have kids?
Yes.
How many?
1.
1? How old?
He's 2.
All right. Anything else, Mr. Brown?
No, he's not.
Okay. I appreciate you being here throughout the trial. Thank you.
Yes, okay.
Thank you.
Hello.
Hello.
My name is Sherry Malone, and I am the mother of the deceased Tyrone Hardesty. He was my oldest son. I just feel like he was just taken away from me. We were real close. We just was close. I just don't understand this right here. I don't. Why? But man, I have to explain to my granddaughter. She's 4 years old. She always asks me, when my dad coming back? I mean, I don't, it's just hard on my family. My daughter, she couldn't even come. So it just hurt her. She been hurt and not working or nothing since this happened. And I just want the court to know that you took a fine young man He was. Not just saying that because he was my son. He hadn't been in no trouble since 2006. He was trying to do the right thing. He was putting his music out there, posters everywhere. Why would he do something to jeopardize that? He had made a movie for Tubi. All his music on Spotify, Apple, and we've been getting a lot of hits or whatever, but he not here to see that. And he always told me, Mama, I'm gonna make you rich. I'm gonna do that for you, Mama. And it just hurt me so bad. He was my first love. No man, nothing but my first love, my child. It's gone way too soon. Just way too soon. No, it's senseless. And I want justice for him today. Thank you.
Ms. Malone, thank you for being here. One quick question. Your granddaughter, meaning Mr. Hardesty's daughter, who does she stay with her mom?
Her mom.
Okay. All right. But you get to see her
all the time.
All the time. Good. Okay. Thank you.
Thank you.
Mr. Abadi?
We don't have any additional victim impact statements. Ms. Robin Cook is present. She'd like to make a quick statement now.
Okay. Welcome back, Ms. Cook.
Yes,
Tell me what you'd like to share.
I just want to say that this young man took somebody very special to me. And that night, since that night, has not been very easy for me. And being there and having to meet there that night and dealing with that was very difficult for me. You took somebody very special to me. And I could never get that back. I'm dealing with that every single day, every day. And I don't understand why. And will never know why this actually happened. But I just want to say, I just want justice for Tyrone. All right, that's it.
Okay. Well, Ms. Cook, I appreciate your testimony as well as this statement now. You've taken important steps to ensure that what you are hoping for happens. Okay?
Yes.
Thank you.
With that, Judge, the state's recommendation is to count one murder. The state recommends to the court to sentence Mr. Williams to a sentence of life without the possibility of parole. As to count 5, criminal damage to property in the first degree, 10 years to serve concurrent with count 1, and then count 6, possession of a firearm under the commission of a felony, 5 years to serve consecutive to counts 1 and 5. And recommending to the court a sentence of life without the possibility of parole is not something that I do very often. When I take and understand the seriousness of making such a request, especially a request as it relates to someone who is now 22 years old, as he sits before the court, found guilty of murder and the other related charges. But in this instance, I feel compelled and I feel that it's necessary to make such a request to the court based on the facts and the evidence and how they unfolded in the courtroom over the last week during this trial. It was uncontroverted that Mr. Hardesty was shot in the back 6 times, and it was clear, at least to the state, based on the evidence, he was shot not knowing that anybody was watching him, that a gun was on his back. As he finished wrapping presents, or was about to finish wrapping presents, once he got the flyers out of his vehicle, he was gunned down, and we may not know why, but in the state's opinion, I don't need to know why. I know that the violent acts that this defendant took are heinous, they are unconscionable, and to be frank with the court, in looking at some of the documents in the jail screen here, as he has been at the Fulton County Jail, he's not, the lack of remorse for this instance has continued, as he most recently, there's reports that he stabbed an inmate while the inmate was sleeping. So in taking all of the totality of the circumstances for this case and the defendant's continued behavior, the state's opinion is the only appropriate sentence as it relates to count 1 murder is life without the possibility of parole. And then the remaining counts, count 5, 10 years to serve concurrent. And then count 6 must run consecutive, 5 years to serve consecutive to counts 1 and 5.
All right, thank you. Ms. Feely?
Thank you, Your Honor. As the court has heard, Mr. Williams is 22 years old. He was 20 at the time that this happened. At the time that this happened, he had no felony record. He was born into a situation where he lacked some supports that he needed and an environment that lacked opportunities. He's got 3 brothers and a single mom living where he lived at the Columbia Commons. My sense from working with him is there's some undiagnosed, maybe mental health issues that he was self-medicating with various substances that he had access to. And we are not minimizing the seriousness of this crime or the hurt that was caused by his actions, but we are respectfully requesting the court consider his record and his age. And we're asking for, on count 1, life with, and on count 5, a concurrent 10, and then on count 6, the 5. And that he be given credit for time served since January 11th of 2023.
All right. Mr. Williams, you have a right to say anything if you want to. You don't have to say anything at all, but much like the victim's family has a right to be heard in a setting like this, you've got a right to be heard. And I got to hear from you some because you testified, but if there's anything more you want to say, now would be the time to say it. But just like your decision to testify, you don't have to say anything more if there's nothing more you think needs to be said.
It was an accident that harmed Tyrone. However, this was definitely for no reason. That man robbed me. That man took from me, whether people believe it or not. And how I feel, before I take a license, I would rather die, honestly. And unfortunately, I'm not gonna be able to see my little girl. She's 9 months. I didn't even get to see her when I was out because my baby mother was pregnant with her at the time. However, it's still in my beliefs that this is not justice. I defended myself and I was robbed and beat by that man. I did not want to harm this man. His actions led to his consequence.
All right, Mr. Williams, appreciate you sharing that. I struggle with some of the same things that Mr. Brown and Ms. Malone shared, which is Mr. Brown said it doesn't make sense. Ms. Malone says it's senseless. It just doesn't add up. Whether you were afraid of Mr. Hardesty or not, whether we credit your version of events to the point where you're way up on the 3rd floor balcony, you had so many opportunities to get out of that situation. But what you chose to do was to fire at the man, whether he had a gun or not. The jury listened carefully to what you had to say and found your version of events to be not as compelling as all the other evidence that they received. And there are many tough aspects of this. There are a lot of broken relationships and empty seats at tables. Primarily, I worry about Mr. Hardesty's family, his daughter, and his family. But there's another empty seat, and that would be where dad ought to be sitting for your daughter. You're not going to be able to sit there and help take care of her because of the choices you made on December 22nd, 2022. And the toughest part for me is that the way Mr. Brown and Ms. Malone and Ms. Cook talk about it, where you took something, no one can get you to give it back. You took something, but what you really did was destroy something. Mr. Hardesty doesn't get to come back. People have the memories, but the steps you took are as permanent as they can be. You didn't take his car and people are sad and maybe you get the car back or insurance pays for it. But you took a life, and those are things you can't give back. And for that, the consequences are very, very serious. No one's going to gain from the fact that you're going to spend many years in prison. You will spend more years in prison than you've been alive so far. That's a strange outlook that you're going to have. And none of that brings Mr. Hardesty back, but it is the appropriate consequence for your decision to fire not once or twice, but at least 6 times at a man who the physics don't lie. His back was to you, and it's hard to square that with a claim of self-defense. But I don't need to resolve that. The jury did, and I'm left with a verdict for a 22-year-old who has no adult felony criminal history. And as I balance all those things and the notion that a sentence is designed to punish and there's punishment coming your way, but it's also to be focused on rehabilitation, and it needs to be proportionate. You don't have the background that convinces me that but for locking you up, more people are going to die. I see defendants like that, and that's not you. I'm going to sentence you, Mr. Williams, on count 1 to a term of life in prison. Counts 2 and 3 are vacated by operation of law. 4 merges into 1. Your sentence on count 5 is 10 years to serve. That will run consecutive to count 1. Count 6 must be 5 years, and it must run consecutive to the highest count, which now is count 5. And I am making that a term of incarceration as well. So your sentence is life plus 15 years. You will get credit for the time you served. I need to talk to you about your appellate rights. Ms. Feely will talk to you about this more, but the important thing is that you've got 30 days to have Ms. Feely to file on your behalf either a motion for new trial, which is you saying, Judge, there were mistakes made, you made them, my lawyer made them, and I ought to have a new trial. Or, and you do one or the other, a direct appeal to the Supreme Court because you've been convicted of murder. Your case goes straight to the Georgia Supreme Court, appealing whatever mistakes were made here. You can do both, however, and your lawyer may advise you, we'll start with the motion for new trial, because if I deny that motion, you still get to appeal to the Supreme Court. But you need to decide that. And my request to Ms. Feely before she withdraws from the case, because you'll get a different lawyer appointed to represent you before she withdraws from the case, that she consult with you. And if it is your decision to file the motion for new trial, she takes care of that. If instead you want to just go straight to the Supreme Court, she files that notice of appeal. When you've exhausted your what we call direct appeals, which ultimately would get you to that Supreme Court, or if you choose not to pursue them at all, in other words, you let those 30 days pass, you also have 4 years in which to file what's called a habeas challenge. That's actually a civil lawsuit. You don't have the right to an attorney to help you with that. You'll have an attorney helping you with all those direct appeals I just described. You don't need to worry about paying for that. But once you get to habeas, that's you. And if you can hire a lawyer, it's your lawyer helping you. Otherwise, it's you doing that but that deadline doesn't start running until you decide you're done with your direct appeals. Then you've got 4 years after that to challenge the constitutionality of your conviction and your sentence. Do you feel like you understand the deadlines that you have, Mr. Williams?
Yes.
Okay. Ms. Feely, you'll consult with Mr. Williams about those?
We've talked a little bit, but yes, I'll.
Okay, and whatever his directions are, you'll take those steps and then we'll work on, if it's to pursue some form of a direct appeal, we'll make sure different counsel gets appointed. All right, thank you. Mr. Bate, anything else in Mr. Williams's case?
No, Your Honor, nothing further from the state.
All right, Ms. Feely? Do you have a question? A statement. So we're past the statement times. You can talk with Ms. Feely back there, but I got to hear your statement, and we're going to move past that. I would ask Deputy Gordon that you contact your colleagues at Union City based on Mr. Williams's observation about how he's feeling right now, so that people are keeping eyes on him. Okay? All right. Thank you. Mr. Brown and Ms. Malone and Ms. Cook, this doesn't bring Mr. Hardesty back, but it's a new chapter now. It's not a case where nothing was done about this debt. It remains senseless. It doesn't make sense. And it's now not the case because that sentence was imposed that Tyrone's going to pop up in your life tomorrow. The memories are there, and you should know that everyone took this seriously. Mr. Abate worked real hard with Mr. Rao to bring this chapter to a close. And my hope for the three of you and everyone else who's been touched by this loss is that while you never forget, you know that other people didn't forget either. And hopefully that brings a little bit of solace as you try to move forward. But I appreciate you all being here, okay? All right, thank you.